Let's talk about Michigan's implied consent laws and what a breath test refusal or a blood test refusal means under Michigan law. Every one of the 50 states has implied consent laws on the books, and implied consent laws have received formal endorsement by the United States Supreme Court. They've approved of this. When you get your driver's license, when you agree to operate a motor vehicle on the roads, you give implied consent that if you are arrested for a qualifying offense, a drinking and driving offense, you give implied consent to the state that you'll submit to a chemical test, whether it's breath, blood, or urine, depending upon which state you're in. Michigan is a little unusual in that we don't refer to this primarily as implied consent generally. In the statutory language, it's called implied consent. And we understand what the implied consent laws mean, but we call them chemical test rights and chemical test refusals. Michigan has always been a little unusual with its DUI practice. We have OWI and operating while visibly impaired, whereas most states it's DUI or DWI. Michigan has always marched to a different drummer. But in Michigan, if you are arrested for an OWI or some other qualifying offense, such as drugged driving or driving under the influence of an intoxicating or impairing substance, the officer will read you chemical test rights after you are arrested. Anything that happens before the arrest, we'll deal with in a different issue, but implied consent is when the officer reads you implied consent warnings, which we call chemical test rights. As you can see up on the board here, I have a copy of a request for hearing. This is part of a packet of information that police officers use all across the state of Michigan. If you engage in a chemical test refusal, they will give you this paperwork. It's called the DI-93. The DI-93 is issued in chemical test refusal cases as opposed to a DI-177, which is a temporary driver's license granted to a person while there's a drunk driving case pending. This is 4 pages, front and back. It's 2 actual pages, but front and back, a total of 4 pages. This request for hearing needs to be sent to the Secretary of State within 14 days. If you do not submit it within the 14-day period, your license is automatically suspended, even if you did not refuse to submit to a chemical test. This is just based upon what the officer alleges in the paperwork. Let's go on to page 2 here. Page 2 is the request for hearing submission that you have to fill out. Now, I'll help you fill this out if you hire me to represent you at the Secretary of State. We are requesting a hearing on issues 1 through 4. On this form, it doesn't really specify what those issues are. We'll see that later on in the other paperwork. Here is the temporary driver's license. Now, this is a DI-93 temporary license, which only remains effective for 14 days unless you request that hearing. On the back of this form, this is the chemical test rates down at the bottom. We'll read through that in just a moment. But as you can see, the notice of suspension up at the top gives you your 4 issues that you're allowed to contest at the Secretary of State. Disregarding the actual language that's in this paperwork, essentially what you are able to challenge is whether or not the officer had a lawful traffic stop, whether or not the officer developed probable cause to make an arrest for one of those quote unquote qualifying offenses. Did the officer do field sobriety tests, or was there a PBT, or was there probable cause to arrest for drunk driving, essentially? Did the officer read you the chemical test rights that we're about to review? And lastly, was your refusal reasonable overall? So let's talk about the chemical test rights. The officer is required to read these to you. It's prefaced in the DI-177 as, I am a peace officer and and you were under arrest for, and they'll read off the offense of what you're arrested for. It then goes into these chemical test rights. Let's read them together. I am requesting that you take a chemical test to check for alcohol and or controlled substances or other intoxicating substances in your body. If you were asked to take or took a preliminary breath test before your arrest, you must still take the test I am offering you. That is talking about the preliminary breath test. I can't tell you how many clients I have that are captured on video in their exchange with the officer, but I already blew out on the side of the road. That test does not count. The preliminary breath test on the side of the road, first off, you should always refuse the PBT on the side of the road. It's a civil infraction. There's no points. It doesn't abstract. It's like a $100 to $200 fine in most courts. Never submit to the preliminary breath test unless you're absolutely positively convinced that you're going to blow all zeros. Take that ticket for the PBT refusal. The chemical test writes the implied consent penalties, however, 1 year suspension and 6 points on your license, far more concerning, right? So on a first offense, I normally tell people submit to the test. Don't get into an argument with the officer over these chemical test rights, though. When the officer says if you were asked to take or took a preliminary breath test before your arrest, you must still take the test I am offering you. This is the actual intoxilizer that you're going to be taking if it's a breath test or a blood test. If you refuse to take this chemical test, it will not be given without a court order, but I may seek to obtain such a court order. That's telling you that the test won't be given if you don't consent under implied consent. But the officer can go and seek a search warrant to compel a blood draw. Now, if you're diabetic, you don't consent to a blood draw, but a blood draw may be done properly under the law if you are diabetic and there's a refusal and it's submitted to the judge through a search warrant. A search warrant overcomes the statutory prohibitions that prohibit the officers from getting blood tests from diabetics. On the other hand, let's say you're not a diabetic. Let's say you're just an average everyday guy, right? If you refuse the test, the officer may go seek and obtain a search warrant. Now, this surprises a lot of people when you compare it to other states. In Texas, for example, Texas will have what they call no refusal weekends. No refusal weekends occur on like holidays, Memorial Day weekend, Labor Day weekend, Thanksgiving. They will announce this in the newspapers saying that it's going to be a no refusal weekend. In Michigan, it's no refusal all the time. And almost every jurisdiction nowadays will go and seek a search warrant to get your blood if you refuse. Universally, people ask me, hey, what's the best advice? Should I take the test or should I not take the test? We know that the officers are more likely than not to go seek and obtain a search warrant if you refuse in Michigan. So I tell people, listen, you're looking at a 1 year suspension and 6 points just for the refusal, even if you're actually innocent. So on a first offense, the penalty for that, even in the worst case scenario, is a 45-day suspension and probably just restricted privileges for 90 days if it's pled down to impaired. The license penalties for a refusal are far more onerous, right, than the penalties for the drunk driving. So I tend to tell people, listen, refuse the field sobriety test on the side of the road politely, refuse the preliminary breath test on the side of the road, again, politely, but submit to the chemical test after you've been arrested. That said, however, universally is not always good advice because there are occasions where I have the person that refuses and the search warrant is drafted up so shoddily that we're able to get the blood test suppressed. Or when you proceed to trial, the prosecutor drops the ball. They don't have their phlebotomist or they don't have their toxicologist to talk about the blood test when it goes to jury. So there is no universal advice, I guess, when it comes to, hey, should you or should you not submit to the chemical test after you've been arrested? But know this, if you refuse, the officers are more likely than not to seek and obtain a search warrant, and your blood will get drawn if you've refused. Continuing with the chemical test rights. Your refusal to take this test shall result in the suspension of your operator's or chauffeur's license and vehicle group designation or operating privilege, and the addition of 6 points to your driving record. Notice that it doesn't say that it's a 1 year suspension. If you have a prior refusal, a prior implied consent refusal within 7 years, it could be a 2 year suspension. After taking my chemical test, you have a right to demand that a person of your own choosing administer a breath, blood, or urine test. You will be given a reasonable opportunity for such a test. This is a statutory right in the case of People versus ANSI before the Michigan Supreme Court, I think circa 2005, 2006. The Michigan Supreme Court held that if the officers violate the statutory right, that there's really no remedy. You don't get dismissal and you don't get suppression of their chemical test. Instead, there's some curative instruction that's given to the jurors. So you have a right to a chemical test by a person of your own choosing. I suggest to people, go get your blood drawn and pay for that expense of getting your blood drawn at the hospital so that we've got two tests. And about half the time, the officers disregard it or don't take you to the hospital for that independent test, in which case you've got the right to a curative instruction, which isn't exactly powerful, but, it is what it is. You will be given a reasonable opportunity for such a test. Yeah, we know that that's not exactly true. You are responsible for obtaining a chemical analysis of a test sample taken by a person of your own choosing. You have to pay for it, in other words. The results of both chemical tests shall be admissible in a judicial proceeding and will be considered with other admissible evidence in determining your innocence or guilt. And then the officer says, will you take a, and they can pick breath, blood, or urine. As I indicated previously, if you're diabetic and they say blood and they know that you're diabetic, we're going to get that chemical test suppressed under a case called People versus Hyde. They're not allowed to compel you to volunteer to a blood test if you're diabetic. And I've won a lot of cases, or at least a lot of suppression issues with that very issue. Again, they can draw your blood pursuant to a search warrant if you're diabetic, but if they use implied consent, the blood is suppressed. Breath testing, on the other hand, universally, everybody can blow, even though diabetics might produce acetone or ketones that will affect the accuracy and potentially give an elevated reading on the breath test. It's kind of strange. And insofar as urine testing is concerned, I've only had 2 urine tests in my entire career, primarily because the officers wanted to try and check for marijuana back when marijuana was illegal and any amount of marijuana could be used against a person. So the few occasions where I've had urine tests come up, I've been able to suppress them because no one is routinely doing urine tests, and they almost invariably fail to follow the protocols for a urine test. Now, wherever you're located in the state of Michigan, if you have a chemical test refusal, I can represent you, whether it's in the Upper Peninsula or Traverse City or Grand Rapids. All of these hearings are being conducted by the Secretary of State through Microsoft Teams. And I cannot express how much I appreciate the Secretary of State adopting this new technology and kind of staying with the times, because I'm now representing people charged with implied consent refusals across the state. And I'm able to get a discovery pack that's comparable to what you'll receive if your blood comes back over the legal limit and we're trying to defend the case. So for a much smaller sum than what I normally charge for representation on a drunk driving case, I'm able to get a full packet of discovery, defend you at the Secretary of State, and analyze the case and give you the best advice that I can regarding whether or not you've got good challenges to the criminal charges later on. So if you're interested in having me review your case and represent you at the Secretary of State, then a chemical test refusal, really, it encompasses all aspects of the case, and I'm able to do a complete and thorough review of a drunk driving charge for a relatively reasonable sum and represent you at the Secretary of State. Now, winning strategies at the Secretary of State. If you talk to other lawyers, they will tell you that if the officer shows up, you lose. You're hoping for the officer not to show up at the Secretary of State hearing. If you request a hearing and you don't hire an attorney and the officer fails to appear, you win. If you submit the paperwork within the 14 days and you fail to appear and the cop fails to appear, you win again. But police officers, unfortunately, tend to show up at these hearings more often than not. Despite that, I totally disagree with the other attorneys that are out there telling people that if the officer shows up, you lose. Now, yes, it is a lower burden of proof at the Secretary of State to lose your license. They only need to show that there is enough evidence to support inferences of probable cause and a reasonable stop. And the officer's testimony that he or she read the chemical test rates is almost always good enough. And that fourth element as to whether or not your test whether or not you reasonably refused or not, there's very few exceptions where they hold that your refusal was reasonable. I've had hearing officers grant me a victory on a person who was genuinely trying to blow but couldn't. A person who tried to talk to an attorney but was absolutely denied access to a telephone. I've had another occasion where a person was not necessarily conscious at the time that the officer read the chemical test rates and didn't say yes or no. And there was no indication that the person even acknowledged that they had been read these chemical test rates. Very few times, though, do you win on the overall the refusal was reasonable issue, that fourth issue. More often than not, it's a genuine fight regarding the traffic stop or probable cause for the arrest, or whether or not the officer read the chemical test rates and had properly advised the person with these implied consent warnings. That said, though, oftentimes I just negotiate with the prosecutor or the police. So overall, my victory rate at the Secretary of State is right around 70%, despite the fact that so many other attorneys say that if the cop shows up, you'll lose. And I found that in recent time, the Secretary of State hearing officers have actually improved over where they were 20 years ago, let's say, when we had some hearing officers that weren't so great. So nowadays, I really enjoy my practice before the Secretary of State because I'm able to provide my clients with a real tangible benefit by being able to review their case, give them good quality representation at the Secretary of State. And it's not a, well, and then the last instances is when I've got felony cases, we're able to use the refusal hearing for what is essentially a full-blown hearing without the prosecutor in the room. So in felony cases, these can also be very valuable hearings. Last but not least, if you do lose at the Secretary of State, I have an attorney that I work with closely who does circuit court appeals. And that's an additional expense. You have to hire this attorney. He works at his own firm. He's separate from me. We keep a Chinese wall kind of between him and I with our practices so that I can hand him cases that I know things about that he doesn't know things about. And he's able to ethically represent my clients that I turn over to him. And it works out great because he does the license restoration cases, whereas I focus on the actual criminal defense in drunk driving cases. So you can do that appeal if you do lose at the Secretary of State. And chances are pretty good that you'll be able to get restricted privileges through the circuit court, even if you've gotten that 1-year suspension in the 6 points. In any event, if you want to talk to me about your chemical test refusal, feel free to give my office a call and we can chat about your case.